Hello, welcome to Strictly Money. I'm Saijal Patel. They were rich, they were famous, they appeared larger than life. But celebrities like Aretha Franklin, Heath Ledger, and Jim Morrison were not above making big estate planning mistakes. Mistakes that racked up millions in legal fees and caused infighting amongst family members. Joining me now to discuss common estate planning blunders even the wealthy make and the lessons we can learn from them is Michelle Connolly. She's Senior Vice President of Advanced Wealth Planning at Wellington-Altus. Hi, Michelle. Great to have you on.
Oh, it's great to finally connect, Saijal.
So I am really glad to have you on because I keep saying this, Michelle, it's so important to get estate planning in place. If you don't want your beneficiaries or you want them to have peace of mind, if you don't want infighting, if you don't want lawyers to get, rich off your mistakes, this is important. But why do so many people not do it?
So when we look at the common misconceptions that people have, including everyday Canadians, such as yourself and myself, in terms of the challenge they have is they don't want to consider the inevitable. And then, I'll get to it tomorrow, maybe next month, next year. Or when we look at who their beneficiaries are, and they're like, my children aren't ready, or in terms of who I'm going to give to, I'll decide. And what also another common challenge is cultural beliefs that with respect to sharing their legacy, sharing their values or beliefs, or the topic of money, sort of prevents those dialogues or those necessary dialogues as to what's going to happen. Often when I'm in terms of meeting those challenges with clients, it's like, okay, let's calm down. Unfortunately, accidents occur, or in terms of putting it off sometimes is worse than talking about it now. And let's take just baby steps, left foot in front of right foot, and let's start the dialogue or start the understanding such that these mistakes or blunders, as you call, don't occur.
Yeah, Michelle, I was going to say, how much of these issues do arise because people don't like talking about money and they don't want to rock the boat when it comes to telling their beneficiaries what they're going to do or not going to do?
So it happens more than you think. And, as advisors, so we call ourselves advisors, when it would be at wealth, whether it be tax, whether it be legal. But in this particular instance, I think our role is actually to act more as a facilitator. And it's to ask the questions to prompt action or what if. And going through often with families or in terms of older generations that are struggling to broach the conversation, it's like, okay, let's not talk about dollars. Let's take wealth off the table. However, what about what you want to happen? In terms of from wealth transfer, what you foresee happening, what you want to happen, start the dialogue in the conversation such that if issues arise, or in terms of the next generation or wealth succession plans are sort of like, not so sure, it actually allows our clients respectively to tweak or to put the tools in place such that success is met. Or take that proverbial toe and step it. Talk about what your legacy or your wealth transfer plans are. And, you don't have to talk about dollars today or tomorrow, but start the dialogue so that you can manage expectations or that communicate and that everybody involved has a general understanding of what to do.
Michelle, we have about a minute to the commercial break. Do you think there's still this belief that only the wealthy need a plan and maybe even a will? Because I come across people who think, well, mine's really simple, so the government's going to decide on a formula, or you know what, it's going to go to my spouse anyway. So what do I have to worry about?
So that's a common misconception. Here in Canada, succession laws are a provincial territorial mandate. So what happens across Canada may differ. Now, when you say just celebrities or the ultra high net worth Canadian, Yeah. I'll put myself on the table. My husband and I have been married for 20 years. We've actually redrafted our wills 3 times. Number 1, when we got married. Number 2, when we were expecting in terms of our children. We had 3 children in a very quick order. And then also when we looked at our daughter was diagnosed with a life-threatening illness, so who could advocate for her? And when we look at the last 20 years, let's think about ourselves, Saijal, like go back 30, 40 years. Yeah. Did you ever think real estate would be 7 figures?
Yeah.
And from that end, it's having that dialogue, and like even looking back at the last 5 years, life has changed.
Life has changed.
And ideals have changed.
And circumstances definitely changed, and it needs to keep up with that. All right, we're going to take a quick break, and we'll be right back. Welcome back. Michelle, let's talk about the estate planning mistakes that celebrities make and what we can learn from them. The first one is Aretha Franklin, right? She died 2018. She had 4 sons. Now, she didn't have a will, or she had an invalid will. I've read both. I've read that there was a bunch of handwritten, unreadable ones. So walk us through what happened.
So as you've touched on, Aretha unfortunately passed away at the age of 76 in 2018. And when we look at the circumstances that led up to her death, we always have to ask why. Like, why did this happen? So we know, it is rumored, or because I'm not her doctor, I haven't confirmed, but Aretha actually had been diagnosed with pancreatic cancer. And the one aspect about Aretha that most may not know of is early on in her career, she didn't have a positive relationship with a business manager. So she took everything personal. She was a noted control freak over her career and in terms of personal life. And we know that she had 4 sons. The eldest did have some special considerations. And when we look at in terms of not planning, I'm sure with her diagnosis, as you touched on, there were 3 handwritten pages. However, none were dated. So in terms of which could be identified as her last in terms of wishes from that end. And when we look at this, the consideration is why. She did have wealth. She did have a beneficiary that had special considerations. She, in terms of oversaw all aspects of her career. All right, why in terms of her legacy, in terms of her state, did she not go take that next step and oversee and outline what she wanted to happen? Because it did go back and forth in terms of which was her final intentions. But given the fact that it was not a proper will, no one could identify what was her last will and wishes, that it meant court delays, it meant legal fees, it meant her privacy, which was valued by her, was given no regard. It also meant she could not direct as to the distribution or who would oversee her estate in the fashion or direct as to what she wanted to happen. It basically went through the courts and then according to a formula. And when we take this back, we think, oh, celebrity, have all of these, she had advisors, to look after her, but that wasn't the case.
Yeah.
And what was the result? The result was, so if Aretha had lived in Ontario, and remember I said will and succession acts are a provincial mandate. If she had lived in Ontario, her estate would have been locked for at least a year. And I'm sure Aretha was supporting her son during her lifetime, provided the care and oversight that he needed. Well, in that lockdown of a year, it would be up to the courts to decide whether or not to continue that care or oversight, or who would continue to overseeing the affairs of the eldest son.
So is, in this case with no will and she didn't have a spouse, would it just be equally divided amongst the 4 sons? And is that what happened? Has it been resolved?
So it's under in terms of seal. Now, if she had, because she had no spouse, and that's actually a common fallacy, like in an intestacy situation, most people assume, oh, my spouse is going to get everything. No, that's not the case. And it varies amongst the Canadian provinces and territories. There is something called a preferential share that a spouse or common law partner would be entitled to. And also the definition of spouse versus common law partner is not treated the same across the Canadian provinces and territories.
That's right.
And the preferential share varies amongst the provinces and territories. So in this instance, it is believed that her estate ultimately was divided amongst her 4 sons. But the question is, did her eldest son have the capacity to oversee his affairs? And, you touch on beneficiary needs. All right. What if her children had been minors? Or in the instance of her eldest son, is he a vulnerable person? If appropriate oversight is not outlined in that instance, across Canada and the various provinces and territories, those particular mandates or inheritances would naturally go to the government and the respective, in terms of oversight, body that oversees vulnerable persons or minors.
Okay.
From that, in terms of, and who may not direct or care for that beneficiary as the testator would want.
Okay. We're going to take a quick break, but I guess the conclusion is one, sometimes a handwritten will might not do it. You have to know, because it can make it invalid, can't it?
Well, and it's up to date.
Yeah.
Like in terms of when you look at life changes.
Yeah.
So yeah.
All right. Okay. We'll continue this conversation. We'll be right back. Welcome back to Strictly Money. I'm here with Michelle Connolly of Wellington-Altus. Michelle, we talked about Aretha Franklin and leaving an intestate. Her will wasn't valid. Let's talk about Heath Ledger, because he died unexpectedly at a young age, 28. Now, he had a will, but it wasn't updated. So walk us through what happened there.
So we've all heard about Heath Ledger in terms of born and raised in Australia, moved over in terms of to the US, met critical acclaim as a film actor. And in terms of talking about, how life changes, or in terms of changing beneficiaries, life instances to revisit wealth transfer planning, let's take a look at Heath. So Heath, like I said, in Australia, actor, all right, did draft a will. And it's rumored that in his will, he left 50% of his estate to his parents and 50% of his estate to his siblings. So came over to North America, met Michelle Williams, the love of his life. They had a daughter named Matilda, okay? And Michelle and he did go their separate ways, but in terms of his daughter, Matilda, apple of his eye, loved dearly. As we're aware, Heath unfortunately had an untimely death. And in terms of what stayed true was his will that was drafted in Australia. Did not reflect in terms of Matilda, his daughter, in his wishes. Now, there's two aspects here. So, new beneficiary, child, all right, did it reflect his current wishes? Also, jurisdiction. So, this will was drafted in Australia. However, the question is, was Heath a resident? So, therefore, the succession laws, would it be Australia, or in terms of he was residing in the US?
Yeah.
And would the succession laws of Australia apply, or would the succession laws of the US apply to administration of his estate?
Well, I guess it worked out okay, because from what I heard, the parents and the sisters did gift everything to Matilda. At least that's what the reports say. So what's the takeaway for viewers, that this jurisdiction matters? And it must matter even if you move across Canada, I'm assuming?
Absolutely. So we touched on, in terms of, like I said, provincial territorial mandate for succession law. So, we've touched about Heath about moving from Australia to the US, but let's talk. So it's just not a different country. In Canada, if you move from British Columbia to Quebec, or say Ontario to Nova Scotia, all right, the laws of intestacy in terms of the formula, but also in terms of, are the provisions in your existing will valid in terms of the provincial or territorial jurisdiction that you now reside in? Keynote is Quebec is a civil code jurisdiction, unlike all other provinces, which are common law. But when we look at British Columbia, their Will, Estate and Succession Act, very, very progressive relative to the other provinces. We look at the definition of spouse or common law partner. Alberta has an adult independent partner, which is a far more broad dependent when we look at that in terms of administration.
Okay. Let's talk about Jim Morrison. This one's a really interesting one because he was the lead singer, obviously, of The Doors. This was a famous dispute. He was unmarried. He didn't have children. He was estranged from his parents. He also had a will, but he left his entire estate to his girlfriend, Pamela Corson. So
the way that I always like to frame Jim Morrison is, who do you think ultimately inherited his estate? And when we look at Jim Morrison, or we look at Heath, or we look at Aretha, their estate isn't just the assets that they had at the time of their death. It's also all the intellectual property that's associated with them being an entertainer, royalties in terms of control over their likeness from that end. So when we look at Jim Morrison, I'm going to ask you, Saijal, who do you think ultimately inherited or had a say over his estate and continued to benefit from his estate in terms of royalties or controlling his likeness?
Yeah, I know the answer to this one because I did my research, but his in-laws, who we didn't like very much.
All right. So in his will, Jim did draft a will, and it said, if my spouse, Pamela Corson, ultimately survives me for 4 months, she will inherit everything.
Yeah.
So Pamela Corson did, of course, survive Jim. So she received like his assets, but also rights to intellectual property, royalties from that end. Now, unfortunately, she passed away 2 years later, I think 2 to 3 years later. And when we look at the laws of succession and intestacy, she died without a will. Now, when we look at succession and intestacy, you generally look down, all right, to children, grandchildren. In the instance that there are no issue, children or grandchildren, you then look up.
Right.
And
Michelle, hold your thought, because we're gonna take a quick break. We have to go to commercial break, but I want you to continue this conversation and what happened. Welcome back. Michelle, we were talking about Jim Morrison and how his in-laws got his estate. So continue the conversation. What happened?
So in brief, like I said, Pamela unfortunately died. And under the laws of succession, because they didn't have issue children, it went ultimately up to her parents. And while Jim did not have a fantastic relationship with his parents or his siblings, they ultimately did not have a say in his estate. There were rumored challenges back and forth between the families, but, you know, thinking what if, or in terms of as a couple, common law partner or married, you know, looking at your wealth transfer plans collectively, you just keep asking, what if this happens? What if this happens? Because I don't think Jim intended to his in-laws to ultimately control his estate.
Yeah. And like, I guess one lesson is, shouldn't you sit down with your partner to make these wills in the first place? So they're both done at the same time. And I guess if someone passes and the other one, what happens to protect the original person's wishes? Because what's to stop the spouse from changing the will anyway?
Very little. Like in terms of, so the one downfall here is Jim did not ensure that Pamela at least had, you know, will in place. So therefore it was the laws of intestacy that governed. But in terms, if they in their relationship had, you know, drafted wills, that his intention at that time would have been in terms of successful, but you can't stop Pamela for 5 or 10 years down the line to redraft her wills and change her testamentary intentions.
Yeah.
So there isn't a handcuff in that regard.
That's interesting, isn't it? Well, we have a board, and this is something you gave me, the 5 triggers to review your wealth transfer plan. So this is when you really have to think about it. I know we've covered a few of them. The one I really want to touch on is the change in relationship status, and why it's important to review your plan when these things happen.
So as we've touched on, the succession laws are different amongst the provinces and territories. How they view common law partner, how they view. So here in Ontario, common law partner wasn't really in terms of recognized under the laws of intestacy, only a married spouse. Mm-hmm. But that is changing, and across the provinces, it's changed very rapidly. Like in Alberta, like I said, the adult independent partner. Also how you treat children, grandchildren, beneficiaries, or if they have a specific need, you know, from that has to be addressed. It's okay, how does this influence or change my wealth transfer plans? The other aspect, Saijal, which a will is not an entire estate plan. There are various tools that entwined actually are the wealth transfer plan. And, you know, from that end, just don't think that a will is going to cover it off. Mm-hmm. You have to combine all and consider all.
What about the other trigger, because you touched on this, right? The purchase of real property. I have to think that this becomes more and more important as the value of property is going up in Canada.
And it's making a substantial asset in one's estate. Mm-hmm. So in terms, when I look at this, and I drafted my first will when I purchased my first condo. Now, that is obvious because if I were to pass away, it would be the province of Ontario that would govern the distribution or how the sale of my condo is handled. It wouldn't be a family member. What really resonates when I'm having this dialogue with clients is parents or grandparents. Most of us have clients that are very generous, and in terms of helping the next generation dip their proverbial toe in the real estate market, whether it's a loan or whether it's a gift. So you make that gift. My suggestion is also give another $1,500 such that that child or grandchild drafts a will with respect to the distribution of their real estate. Because if not, and they die intestate, again, it's the province. And let's say 2 or 3 years down the line, they meet the love of their life. And we have to think about spouse and preferential share from that aspect in terms of real estate. In Nova Scotia, the preferential share could be the marital, or in terms of the home, principal residence. So just guard off. You could have that loan or it could be a gift, but, well-intentioned, make sure they also draft a will.
So smart. And just a little bit of proactive planning can save a lot of heartbreak, can't it? Michelle, really appreciate your time today. Thanks for coming on.
Thank you, and have a fantastic day in summer, everyone.
Thanks. Michelle Connolly of Wellington-Altus. Well, that does it for this episode of Strictly Money. Do you have a story about estate planning that you'd like to share, or questions about this or previous shows? If so, please drop us an email at info@thenewsforum.ca because we'd love to hear from you. Thanks for watching. Until next time, stay well, stay wise, and stay wealthy.